As you certainly know, the vote was taken and former President Donald Trump was acquitted by the Senate yesterday.
The results of the vote yesterday surprised few, but the proceedings took some twists and turns to get there. Bruce Rogow is one of South Florida's most notable constitutional law attorneys, founding professor at Nova Law, and for half a century involved in civil rights and civil liberties cases, with a client list as diverse as businessman Donald Trump, recently Roger Stone, and not so recently, South Florida music giant Luther Campbell. Bruce, so good to have you with us today.
Bruce,
nice to be with you both.
We are so glad you are. Let's begin with something that both Rick Scott and Marco Rubio said. They said, as horrific as the events of January 6th were, that the Senate didn't have jurisdiction. They could not impeach a president who was out of office. Now, I'm not asking you to opine politically, but in fact, the Constitution does not preclude an impeachment for a president who has left office. In fact, are there not precedents that say a federal official can be impeached once he or she is out of office?
There are, of course, and the House managers presented those precedents, and obviously, majority of the senators agreed, although not the two-thirds majority necessary.
You know, I think one of the biggest questions people have since yesterday, who watched what went down on a Saturday afternoon, is that the House managers won the right to call witnesses and detailed especially why they wanted to call witnesses. It seemed like earning that right was a big coup for the House managers, and then they didn't call witnesses. What happened there?
Well, I think they got in what they wanted with the statement from Congresswoman Herrera, because I think that was the major point that they wanted to make, that during the insurrection, during the uprising, the president, former president, knew what was happening and didn't pay any attention to it, basically, actually kind of threatened the House minority leader. So I think they got what they wanted. I think, you know, this was a strange event in terms of both what happened and in terms of a proceeding in which the jurors were victims. The jurors actually witnessed what happened. And of course, the jurors also were not impartial because they had their own agendas that they were trying to address, their future as Republican candidates, things like that. So it was both political theater and legal theater. But I think the House managers did a terrific job in laying everything out. And obviously, getting 7 Republican votes is historic in any impeachment proceeding. So you have to give them credit.
Yeah, you bring up a good point. This wasn't a typical criminal trial proceeding. This was a political trial. You being an attorney and able to sort of see things from both sides, and you watched. If you were one of those jurors, one of those senators, how would you have voted yesterday?
Well, you know, it's hard to be impartial in a situation like this, but certainly the evidence was powerful. I mean, powerful, I think, beyond a reasonable doubt, that the encouragement and the promotion of the activities occurred during that January 6th not conference, but the outside events that the president had. And so I thought there was certainly enough evidence to convict him. And certainly 7 Republican senators also agreed. So again, that was a powerful, powerful point. I mean, I think despite the fact that the House managers, quote, lost because of the acquittal, I think really they won because they did something that had never been done before and got people to go against what their party leaders were telling them.
Yeah. Bruce Rogow, you are a celebrated First Amendment defense lawyer. You really represented I first met you when you represented Luther Campbell when he was arrested for a allegedly vulgar album in Broward County. The argument that Jamie Raskin made yesterday on the First Amendment was that whatever former President Trump said on January 6th, he said was not protected by the First Amendment because it was an incitement of violence, and also he said because it violated his oath of office, which holds him to a higher standard. Take us through the First Amendment arguments, pro and con.
Well, the First Amendment obviously is a restraint on government power to penalize and punish speech. So I thought that the Trump defense team appropriately raised the First Amendment issue. But the First Amendment is a protection against government power. And here it was government power, the presidency itself, that was promoting or inciting the violence. So it's an unusual situation, never had one like that before. And, if this ever went to the Supreme Court, it could be an interesting issue. It could even be a 5-4 decision if you strip away all of the surrounding circumstances about people's loyalty and fealty to either their party or to the president who appointed them. So it was not a frivolous argument that they made about the First Amendment. It certainly has some traction, and it really, I guess, provided an opportunity for some of the senators to find a principled way to avoid finding against the president. But I think really, putting aside all of those nuances, the First Amendment in a situation like this does not protect incitement to violence. I mean, there's a federal statute, and the federal statute talks about promoting or encouraging a riot, promoting or encouraging violence. And the Brandenburg versus Ohio case, which was bandied about by both sides during the proceedings, is an important decision. If you look at it literally, it looks like there's nothing you can do unless you're leading the charge and leading the riot and insurrection. But like many things in the law, there are a lot of words, and how people perceive them and interpret them becomes the critical thing. Here, I thought, once again, the House managers had the better side of the argument.
We have about a minute left. In just a minute, the argument, the closing argument, Donald Trump's lawyers said that they argued there is just no jurisdiction here for this question, which had already been decided prior to that there was. That's confusing to we lay people. Explain that, if you would.
Well, what's confusing is if there's no jurisdiction in a regular proceeding, if a court finds that there's no jurisdiction, the matter is dismissed. Here, the court, in effect, the Senate, found there was jurisdiction. So I think the obligation of the senators was then to proceed as if there was jurisdiction and vote up or down on the merits of the case.
And finally, the argument about no due process. In fact, under this kind of impeachment process, the trial itself was the due process, wasn't it?
It was.
Former President Trump was invited to testify. He chose not to.
Well, that no question about it. He had the opportunity to testify. I mean, due process is the right to be heard. He had the right to be heard. He declined that opportunity. So therefore, it is hard for him to argue there was no due process.
Yeah. Bruce, thank you so much. Great to hear from you. Thank you very much.
Thank you.
You.